This section of the presentation covers the open meeting law's requirements for public body member certification and the open meeting law complaint process. Please note that this presentation is current as of March 2018. Please check with the Attorney General's office to ensure that a more recent presentation has not been published. You can do so by visiting the Attorney General's open meeting law website at www.mass.gov/AGO/open-meeting. There are two types of open meeting law complaints. First, we will review the administrative complaint process. This process allows any person who believes that a public body or member of a public body has violated the open meeting law to file a complaint. The complaint must be submitted on a 2-page form available at the Attorney General's website and often available with municipal clerks. Complaints must be signed and are considered public records. Complaints must be filed with the public body that is the subject of the complaint within 30 days of the alleged violation, or, if it could not have been known at that time, within 30 days of the date the complainant reasonably should have discovered the alleged violation. If, for example, something occurs during an open session meeting that allegedly violates the open meeting law, a complaint must be filed within 30 days of that meeting because the violation could reasonably have been discovered on that date. However, if a public body violates the law during executive session, it is likely that the violation may not be reasonably discovered until the executive session minutes are released, possibly months later. In that instance, the complainant would have 30 days from the date the executive session minutes were released to file his or her complaint. Complaint should be sent to the chair of the public body. For municipal public bodies, a copy must also be sent to the municipal clerk. Once a complaint has been received by the chair of the public body, the chair must disseminate the complaint to the other members of the public body. The public body has 14 business days in which to meet, review the complaint, and respond. In its response, the public body must inform the Division of Open Government of any remedial action taken. Copies of the public body's response to the complaint must be sent to both the complainant and the Division of Open Government. A public body may request from the director of the division an extension of time to respond to the complaint if it can show good cause. It is important that a public body review the complaint and decide what action to take. This discussion can be conducted in executive session pursuant to Purpose 1, to discuss complaints or charges brought against a public officer or individual. Once a public body has reviewed a complaint, it may direct the chair or legal counsel to respond on its behalf. It is not appropriate, however, for the chair or counsel to respond to a complaint before it has been reviewed by the public body. If the complainant is not satisfied with the public body's response to his or her complaint, he or she may file the complaint with the Division of Open Government. The complainant must wait at least 30 days after he or she filed the complaint with the public body before doing so. To be considered timely, the complaint must be filed with the division no later than 90 days after the date of the original alleged violation. The Attorney General's office will not review anonymous complaints or allegations that were not raised in the initial complaint filed with the public body. In most circumstances, complaints filed with the Attorney General's office and documents submitted with the complaint are considered public records and are available to any person upon request. After a complaint has been received by the Division of Open Government, the division will send a letter to the parties acknowledging the complaint. The division will then review the complaint and, if it's timely, conduct an investigation. As part of the investigation, the division may request documents from the public body, such as executive session minutes. The division may also interview members of the public body or others with knowledge of the events at issue. The division will then determine if a violation has occurred and whether any violation found was intentional. The division will also consider any action taken by the public body in response to the complaint to determine if the action was adequate to resolve the complaint. Finally, the division will resolve the complaint through a letter. The letter may be brief and informal or take the form of a more formal determination with a review of the facts and law. Any finding of a violation may include an order for remedial action. A public body that has been found in violation of the open meeting law has the right to appeal that decision in Superior Court within 21 days of receiving the Attorney General's determination. If a complainant files 5 complaints with the same public body or within the same municipality within 12 months, the public body may request mediation upon the 5th or subsequent complaint in order to resolve the complaint. If the complainant refuses to participate in mediation, the division will decline to review the complaint if it is subsequently filed with the Attorney General. The public body must request mediation prior to or with its response to the complaint and will assume the expense of such mediation. If the parties cannot come to an agreement after mediation, the public body will have 10 business days to respond to the complaint, and its resolution will proceed in the normal course. Mediation may occur in open session or in executive session under Purpose 9. In addition, a public body may designate a representative to participate on behalf of the public body. If mediation does not resolve the complaint to each party's satisfaction, the complainant may file the complaint with the Attorney General. The complaint must be filed within 30 days of the last joint meeting with the mediator. The mediator will be chosen by the Attorney General. If the complainant declines to participate in mediation after a request by the public body, the Attorney General may decline to review the complaint thereafter filed with our office. A public body may always request mediation to resolve a complaint, but only mediation requested upon a 5th or subsequent complaint triggers the requirement that the complainant participate in the mediation before the Attorney General will investigate the complaint. Any written agreement reached in mediation must be disclosed at the public body's next meeting following execution of the agreement and will become a public record. If the Attorney General conducts an investigation and finds that a public body violated the open meeting law, there are several statutory remedies that the Attorney General may order. The Attorney General may compel immediate and future compliance with the law. This means that the public body has been put on notice that this conduct violates the law, and future similar violations may be found to be intentional. The Attorney General may compel a public body to attend a training on the requirements of the open meeting law. The Attorney General may compel the public release of executive session minutes or other confidential documents used at a meeting. The Attorney General may nullify any action taken by a public body in violation of the open meeting law. The Attorney General may reinstate an employee and make him or her whole. This remedy may be appropriate where an employee was not afforded the rights guaranteed by Executive Session Purpose 1. And finally, the Attorney General may impose a civil penalty of up to $1,000 on a public body for each intentional violation of the law, but this penalty would not be imposed until after a hearing before an administrative law judge. The law allows the Attorney General to order other appropriate relief, such as revocation of the right to use remote participation. In addition to the administrative complaint process just discussed, there is an alternative complaint process that does not require filing a complaint with the public body or the Attorney General. Instead, the Attorney General or 3 or more registered voters may initiate a civil action in court to enforce the open meeting law. Complaints against state public bodies must be filed in Suffolk Superior Court. For all other public bodies, the complainant must file in Superior Court in the county in which the public body acts or meets. Let's briefly review the topics covered by this entire presentation. First, public bodies must post notice for every meeting. The notice must be posted 48 hours in advance, except in an emergency, and include the date, time, and place of the meeting, and sufficiently detailed list of the topics the chair reasonably anticipates will be discussed. Meetings must be open and accessible to the public unless a public body meets in executive session. Executive session discussions must fit within one of the 10 purposes for executive session, and the public body must follow the necessary procedural steps before entering executive session. A public body must take and maintain accurate minutes of every open and executive session meeting. The minutes must include a summary of the discussion of each topic, must contain all votes, and must contain a list of the documents and exhibits used during the meeting. All public body members must sign the Attorney General's Open Meeting Law certification form within 2 weeks of taking office, certifying that they have read the Open Meeting Law, the Attorney General's regulations, the Open Meeting Law Guidebook, Open Meeting Law determinations issued to the member's public body within the last 5 years in which the Attorney General found a violation of the law, and understand the consequences for violating the law. Finally, all open meeting law complaints must be filed using the Attorney General's form and must be filed first with the public body. The public body must be given an opportunity to respond to the complaint before the complainant may file with the Attorney General. Alternatively, 3 or more registered voters may file a complaint in Superior Court. There are a number of resources available to help you understand and comply with the open meeting law. We encourage you to visit the Attorney General's website, www.mass.gov/AGO/open-meeting. There you will find the text of the open meeting law, the Attorney General's regulations, and the Open Meeting Law Guide. We have also posted answers to frequently asked questions, which are periodically updated and supplemented. The website also includes a searchable database of every open meeting law determination issued by the Division of Open Government and checklists on topics including minutes, notices, and executive session procedures. We thank you for taking the time to view this presentation. If you have remaining questions about the open meeting law, please contact the Division of Open Government. You can reach us by telephone at 617-963-2540 or by email at openmeeting@state.ma.us.